My name is Severyna Magill. I teach at Jindal Global Law School, and this module is for the e-Pathshala UGC. This module will look at the United Nations Bill of Rights and women's human rights. The aim of this module is to place the position of women's rights in the larger corpus of the United Nations Bill of Rights. The protection and promotion of women's interests as we understand them today was absent in the early development of international human rights law. International human rights law has evolved over the decades with the help of treaty bodies and judicial decisions, increasingly adopting adequate measures for addressing women-specific issues. By the end of this module, you will be able to correctly identify which documents form the United Nations Bill of Rights and how they have evolved to become more gender-sensitive and representative of women's needs and accommodating them within law. You will also understand the difference in the way that women's rights were articulated in the early stages of human rights development and when the modern movement started. The UN Charter from 1945 established the United Nations as an international organization. The UN, which was formed as a response to the horrors of the World War II, intended to create global peace and security and cooperation, and to promote the encouragement of human rights and fundamental freedoms across the world. Prior to the UN Charter in 1945, women as a category under international law were not viewed as independent actors, but were seen as extensions or dependents upon men. Sometimes they were even seen as the property of men. The law at the time adopted a very protectionist or paternalistic stance in terms of women, making protection of women and familial honour the basis of women's rights. Laws that treated women differently to men and more akin to children were not new. In the UK, the 1844 Factories Act introduced for the first time a national limit on the number of hours women could work. Men did not have any limits on the number of hours they could work. Whilst it was argued that the intention of the law was to ensure that women were able to spend more time at home with their children, in reality it prevented women from being able to work the same hours as men, and therefore prevented them from being able to receive the same economic rewards. It also reinforced child-rearing responsibilities as only the work of women and not the work of men. These articulations denied women the status of equals and prevented their agency from being legally recognized. To formally pronounce the UN's commitment to human rights and equality between men and women, in 1948 the Universal Declaration of Human Rights was pronounced. The UDHR was the first international document to recognize the principle that all individuals are entitled to human rights and fundamental freedoms without any distinction, including on the basis of sex. As this document was a declaration, it could not establish any legal obligations upon states. The UN Commission for Human Rights therefore set about developing a treaty version of the declaration, and in 1966 the International Covenant on Civil and Political Rights, the ICCPR, and the International Covenant on Economic, Social and Cultural Rights, the ICESCRand, were both opened for signature. The ICCPR and the ICESCRand continued to uphold the principle that men and women should both enjoy equally the rights enshrined within the covenants. The UDHR, ICCPR and the ICESCRand are collectively referred to as the UN Bill of Rights. Key ICCPR provisions for women are Article 2.1, freedom from discrimination on the basis of sex; Article 3, the equal rights of men and women regarding access to the enjoyment of civil and political rights; Article 6, paragraph 5, a prohibition of the death penalty upon pregnant women; Article 23, equality between men and women during marriage, including rights to enter into marriage freely and equal rights at its dissolution; Article 25, to participate equally in public affairs such as voting; and Article 26, equality between men and women before the law. Key ICESCRand provisions for women include Article 2, paragraph 2, freedom from discrimination on the basis of sex; Article 3, equal enjoyment for men and women in economic, social and cultural rights; Article 6, the right to work and access the full realization of this right, including access to training opportunities; Article 7, equal remuneration for work for equal value; and Article 10, protection and assistance for the family, especially mentioning women during pregnancy and childbirth, and access to social security during this time. The Bill of Human Rights affected women's rights. The UDHR, the ICCPR, and the ICESCRand shifted the focus on women from being objects of international law to subjects of international law. Women were now recognised as rights holders and therefore individuals who could engage with law as beneficiaries of rights and not merely as objects who were seen as property. The inclusion of Article 3 in the twin covenants, the ICCPR and the ICESCRand, was instrumental in shifting the focus from formal equality to substantive equality. It was now the state's prerogative to ensure that women's equality be paid special attention. Another significant development was the inclusion of equality of men and women within marriage and in the event of its dissolution under the ICESCRand. This contributed to the breakdown of the traditional approach of separation between public and private spheres. Typically, the public sphere was cognizable by law and the private sphere was held to be outside the reach of law. It also helped to bring domestic violence under the purview of the human rights violations, although this was the Women's Convention, CEDAW, that made the connection in 1989 with the publication of General Recommendation No. 12. A criticism of the protection of women's rights under the twin covenants is that they are based on the male model of protecting rights. This is especially evident in the ICESCRand, where it protects the right to work, but it bases it on the male model of employment. This renders invisible the unremunerated work provided by women within the household and structural barriers that result in women's inequality within the workforce. Similarly, Article 12 of the ICESCRand recognises the right of everyone to the enjoyment of the highest attainable standard of healthcare. Healthcare is seen as both physical and mental health. However, while adopting a neutral position towards the rights of health, the Convention fails to acknowledge a woman's right to reproductive health care, which is fundamentally different to men, and their reproductive self-determination. It excludes reproductive rights from the human rights framework. It is noticeable that Article 25 of the Universal Declaration of Human Rights had recognized the different experiences of women regarding reproduction, and it recognized their right to assistance during motherhood, but this was not included whilst protections for infants was included within the ICESCRand. The evolution of women's rights in the UN Bill of Rights took place in the following way. Almost all UN conventions have a treaty body, normally referred to as the committee. Committees monitor the implementation of treaties in states that have ratified or acceded to the treaty. Committees receive periodic country reports that monitor compliance and implementation of the human rights provisions domestically. With these reports, the committee and the state party are able to engage in a dialogue about the extent of their implementation of the treaty provisions and how fuller implementation could be guaranteed. General comments are the comments adopted by the treaty body established under the respective UN treaty for the promotion and protection of human rights. General comments are not legally binding and as such only apply as soft law. This is because states ratify or accede, in other words legally consent to a treaty, and do not do so to the individual general comments. In the case of the ICCPR and the ICESCRand, the treaty bodies are called the Human Rights Committee and the Committee for Economic, Social and Cultural Rights respectively. This section will now discuss the role of general comments and the development of state obligations. The purpose of general comments is to comment on issues in a general nature and not in terms of a particular state party's implementation. General comments are addressed to all state parties to a treaty. They highlight areas of concern regarding the treaty's full implementation and add clarity to definitions and meanings contained within the treaty to give the provisions a higher degree of substance. The benefit of this process is that particular attention may be paid to areas of the treaty that are not being fully implemented or are not being implemented as fully as the committee might desire. This is often the case when multiple states are demonstrating the same problem regarding implementation. General comments also enable the committee to evolve the notions of equality and morally acceptable and expected forms of behaviour over time. Thus, the standard of implementation by states continually develops and does not remain static like the treaty itself. General Comment 3, issued by the Committee for Economic, Social and Cultural Rights in 1990, introduced minimum core obligations of a state party to a covenant. It provided that once a state is a state party to the treaty, it is under a legal duty to take steps to progressively realise the covenant's rights, and that there are minimum core obligations to ensure the satisfaction of, at the very least, minimum essential levels of each of the rights. The comment stated that if a state was failing to discharge the minimum core obligations, it was failing to meet its obligations under the covenant. Both the Human Rights Committee and the Committee for Economic, Social and Cultural Rights have issued comments addressing the nature of state obligations and asserted that a state has tripartite obligations under the covenant. Tripartite obligations are to respect, protect and fulfill. Respect is when a state itself cannot directly violate the obligations it has assumed under the covenant. The obligation to protect means that the state must protect individuals within the state's jurisdiction from harm perpetrated by third parties. The obligation to fulfill is a third level of obligation. The aim is that men and women should be able to enjoy their economic, social and cultural rights on a basis of equality with each other. In 2000, General Comment number 28 was issued by the Human Rights Committee. This addressed issues of equality and stated that states should take all appropriate steps, including the prohibition of discrimination on the ground, to put an end to discriminatory actions both in the public and private sphere. The Committee for Economic, Social and Cultural Rights provided that the state has an obligation to eliminate discrimination both formally and substantively by issuing a General Comment number 20 in 2009. The move towards ensuring substantive equality required taking special measures for women, recognizing women as a group that have suffered historical or persistent prejudice, rather than comparing them to formal treatment of men and women in similar situations. The Human Rights Committee and the Committee for Economic and Social Cultural Rights have attempted to address issues of reproductive facilities, services and policies through raising concerns of maternal mortality. The Human Rights Committee has linked the issue of maternal mortality to the right to life, incorporating the issue of pregnancy under its mandate. Likewise, the Committee for Economic, Social and Cultural Rights has linked maternal mortality to the right to health. However, the absence of an explicit provision guaranteeing abortion in both of the treaties has led to the continuation of women being unable to access safe and legal abortions. The Committee for Economic, Social and Cultural Rights, when it issued General Comment number 14, specifically talked about the right to health and gave a 4A framework including accessibility. Within this General Comment, it noted that when legal access to safe and hygienic abortion was unavailable, it meant that women continued having to access illegal, unsafe and often unaffordable abortions without explicit legal recourse. It was also observed by the Human Rights Committee in the case of Amanda Mellett v. Ireland that the absence of access to legal, safe and affordable abortions is a denial of a right to privacy, as it interferes with a woman's decision about whether or not to continue with or to terminate a pregnancy. The Human Rights Committee also stated that it violated a woman's right to not be discriminated against, as criminalisation of abortion would only affect women and not men. Women who have to bear the cost and the socio-economic burden of such differential treatment, that is the payment of the costs of travel and seeking terminations of pregnancies abroad where abortion is legal, was therefore seen as discriminatory. The Committee for Economic, Social and Cultural Rights, in its General Comment number 22, specifically addressed issues of reproductive health care and asserted that the state has a positive obligation to take steps to provide access to safe abortion services. Safe abortion requires access to legal and affordable abortion services, and criminalisation of abortion and unaffordable abortions must be prevented. The General Comment recognises that intersectional discrimination against women has constantly remained unaddressed. This would be discrimination not just on the grounds of sex, but also socio-economic status. An intersectional analysis helps in locating patterns of disadvantage created by the interwoven grounds of sex, gender, marital status, poverty, class, socio-economic status, and reliance on social status. General Comment 23, issued by the Committee for Economic, Social and Cultural Rights, is notable. Its emphasis is on ensuring women's substantive equality, wherein it has urged the state parties to address occupational segregation on the basis of sex and the undervaluation of work traditionally performed by women. It also asserted that states are required to take special measures for eliminating structural obstacles that perpetuate gender inequality. In addition to issuing general comments, the committee, which oversees implementation of the treaties, is also responsible for monitoring implementation of treaty provisions within states. As part of this process, the committees receive and reply to, via state interaction, reports filed by the state on the status of their implementation domestically. As part of this process, both the Human Rights Committee and the Committee for Economic, Social and Cultural Rights have recognised the discriminatory impact of not, for example, providing abortion services and the impact this has on women who cannot afford to obtain an abortion abroad. Such statements have contributed towards the development of thought regarding intersectional discrimination. The concept of autonomous norms and state obligations are discussed in this section. Whilst women's interests were historically marginalised through the creation of separate institutions like the CEDAW Committee, the Human Rights Committee has continued to be an instrument that helps to incorporate women's rights within the implementation of the UN Bill of Rights. An important tool in this regard has been Article 26 of the ICCPR. Article 2, Paragraph 1 of the ICCPR states that men and women should not be discriminated against on the basis of their sex with reference to the civil and political rights contained within the treaty. Article 26, however, guarantees non-discrimination generally. It is therefore not limited to only apply to civil and political rights. Because of this difference, Article 2, Paragraph 1 has been called a subordinate norm, because it only guarantees non-discrimination to some specific rights. Article 26, however, has been called an autonomous norm because it guarantees non-discrimination between men and women generally. Article 7 of the UDHR is also an example of an autonomous norm. The Human Rights Committee has relied on the general characteristic of Article 26 to help enforce women's rights. The case of Brooks versus the Netherlands is a good example of this. The autonomous nature of Article 26 was identified in the Brooks case for one of the first times, and it has been identified as one of the few cases illustrating excellent and groundbreaking reasoning. In the case before the Human Rights Committee, the author, Mrs. Brooks, was a married woman. She was dismissed from her employment due to a disability which she attained when she was employed. She received certain unemployment benefits from that point onwards. In June 1980, the Netherlands stopped providing the said unemployment welfare benefits to Mrs. Brooks. The author was told that she, being a woman, was no longer considered the breadwinner of the family and hence did not automatically qualify for unemployment benefits. The Unemployment Benefit Act, at that time enforced in the Netherlands, stated that if the applicant was a man, he would be automatically entitled to receive the welfare support. However, being a woman, she would first have to demonstrate that she was not the primary income earner within her family before she would be paid the support. She felt that this was discrimination on the basis of sex. As the ICSCR did not have a complaint hearing mechanism at the time, she wasn't able to approach the Committee for Economic, Social and Cultural Rights, assuming that welfare should be seen as a socio-economic right. She could, however, approach the Human Rights Committee. When she approached the Human Rights Committee, she relied on Article 26 of the ICCPR and said that this had a general application of prohibiting discrimination on the basis of sex. When the committee was considering her case, they took into account the ordinary meaning of each element of the article within the ICCPR with reference to her case. They began their analysis by noting that Article 26 does not merely duplicate the guarantees already provided for in Article 2, but derives from the principle of equal protection of law without discrimination as contained within Article 7 of the UDHR. They therefore decided that Article 26 could be applied to any law that was currently in force in any of the countries that were a state party to the ICCPR. The Human Rights Committee began its analysis by stating that Article 26 does not merely duplicate the guarantees contained within Article 2, but actually provides much broader protection regarding any discriminatory treatment within law within the state party. For this, it relied on Article 7 of the UDHR to base this interpretation of Article 26 on. This means that any law currently in force in a state party cannot discriminate on the basis of sex. Using this reasoning, the Human Rights Committee decided that the Netherlands had violated its obligations to not discriminate against people within its jurisdiction on the basis of sex, even though it was technically ruling on a socio-economic rights issue. Subsequent to the Brooks case, the Human Rights Committee has, on certain instances, upheld that Article 26 of the ICCPR has autonomous or general application. The autonomous existence of Article 26 was also acknowledged in General Comment No. 18, adopted by the Human Rights Committee. General Comment 18 states, "In the view of the Committee, Article 26 does not merely duplicate the guarantee already provided for in Article 2, but provides in itself an autonomous right. It prohibits discrimination in law or in fact in any field regulated and protected by public authorities. Thus, when legislation is adopted by a state party, it must comply with the requirement of Article 6 and that its content should not be discriminatory. In other words, the application of the principle of non-discrimination contained in Article 26 is not limited to those rights which are provided directly within the Covenant." The autonomous nature of a provision is rarely used in human rights jurisprudence to impose an onerous obligation upon states. The broad interpretation of autonomous norms often conflicts with principles of state sovereignty and state consent. The argument of the government of the Netherlands in the Brooks case illustrates this. It stated that not only was there a lack of an effective complaint hearing mechanism for economic, social and cultural rights, but it also said that there was a common belief that economic, social and cultural rights are non-justiciable. In an effort to justify the application of the ICCPR's Article 26, the Human Rights Committee in its decision stated that the ICCPR could not be used to mandate that laws were created by a state, for example, the creation of welfare support systems, but that Article 26 could impose an obligation upon states if laws already existed domestically that they could not be discriminatory. Claiming that heterosexual marriage laws discriminate against persons in a same-sex relationship on the basis of their sex would use the same reasoning. This, however, has not been utilised, perhaps largely because of the lack of widespread political support for same-sex marriage. Treaty bodies therefore remain reluctant to interfere in such sensitive issues, and uncertainty and unpredictability regarding the reach of autonomous norms persists. Another case discussed is that of Mellett versus Ireland. In 2016, a woman named Amanda Mellett took Ireland to the Human Rights Committee, alleging that Ireland had violated her rights to equality and non-discrimination as found both under Article 2.1 and 26 of the ICCPR. She also alleged violations of her right to equality, freedom from torture, right to privacy, and right to hold opinions without interference by the state. Mellett and her husband were expecting a baby when, in the 21st week of her pregnancy, Mellett was told that her fetus had congenital heart defects, and even if the impairment proved fatal, she could not have a termination of her pregnancy in Ireland. The doctor at the hospital stated, "Terminations are not available in this jurisdiction. Some people in your situation may choose to travel." The doctor did not recommend a suitable abortion provider in the UK. A few days later, Mellett was informed that the fetus had trisomy 18 and would die in utero or shortly after birth. As abortion in Ireland is illegal, travelling to Great Britain either by sea or by air is often the only way an Irish woman is able to access a legal termination of pregnancy. Having learnt that her child would either die in utero or shortly after birth, for the next 3 weeks Mellet was tormented and flew to Liverpool with her husband, where she received medication that started the termination process. 3 days later, the hospital induced labour, and after 36 hours of labour, when she was 24 weeks pregnant, Mellet gave birth to a stillborn baby girl. Due to financial pressures of having to stay in a foreign country and pay for medical treatment out of her own pocket, Mellet had to fly back just 12 hours after the termination was performed. She was exhausted, she was still bleeding, and she was very weak and lightheaded. In order to access the abortion, Mellet was forced to entirely fund her travel, medical treatment and accommodation from her and her husband's personal finances. This not only put significant financial pressure on the Mellets, but was also an economic barrier to receiving healthcare that not all women would have been able to afford. The consequence of this barrier is that women with a lower economic status would have been prevented from being able to access safe, legal and hygienic medical termination of pregnancy treatments. This would mean that some women would be unfairly discriminated against on the ground of their poverty. Once back in Ireland, Mellet wanted to access bereavement counselling to address the trauma of losing a much-wanted child. Whilst the hospital offers counselling to women who have suffered spontaneous stillbirths or whose children do die in utero, the service is not extended to anyone who chooses to terminate their pregnancy. It was argued at the Human Rights Committee that Mellet was denied medical treatment that other women were provided simply because she had chosen to terminate her unviable pregnancy to reduce her own mental suffering and anguish and to prevent seeing her baby die after birth with a lot of suffering. The Human Rights Committee, under Article 26 of the ICCPR, decided that Ireland had violated her rights to non-discrimination. Further, it relied on General Comment 28's articulation of differential treatment and decided that Ireland's treatment did not meet the requirement of reasonableness, objectivity and legitimacy of purpose. It also decided that it did constitute discrimination. The committee also decided that Ireland had violated Mellet's rights to not be subjected to torture, cruel, inhumane or degrading treatment or punishment, and that her right to be free from arbitrary or unlawful interference with her privacy, her family and her home had been violated. It noted that if she had been able to access safe and legal abortion services in a timely manner without having to travel abroad, this would have spared the added anxiety she had to endure. The Mellet decision demonstrates how Article 26 and general comments may be used within judicial decisions to address issues of discrimination against women and to provide a comprehensive understanding of equal rights between groups of women and to protect them from harm. The decision also included recognition of the impact such laws have on women from weaker socio-economic backgrounds and thus also marks a step forward in recognizing intersecting forms of disadvantage and how these may multiply the lived disadvantage many women experience. The conclusion is that women's rights within the international human rights framework have been considered and used synonymously within CEDAW. However, it is important to note that the position of women's rights within the corpus of the UN Bill of Rights regarding the ICCPR, the ICESCRand and the UDHR have been evolving over time to be more representative of women's lived reality, both within the workforce as well as within healthcare needs, particularly reproductive healthcare needs. The Human Rights Committee and the Committee for Economic, Social and Cultural Rights have consistently issued general comments that are much more inclusive of women's reality. It remains important to understand the nature and effect of intersectionality and to encourage state parties to address these complicated impacts. The use of autonomous norms and Article 26 particularly in judicial decisions has, however, been inconsistent. The Human Rights Committee must use this tool more effectively in order to impose more onerous obligations on states to address women's issues in all areas of life. While the process of evolution of women's rights has been positive, the same has failed to be adequate to accommodate a comprehensive protection and promotion of human rights for women generally and for other minority groups as well. This module has demonstrated how The UDHR formed the basis of human rights protections, and when it was evolved into both the ICCPR and the ICESCRand, some notions of protecting women's rights were lost. They have, however, been regained via general comments and judicial decisions that come down from the Human Rights Committee. There is therefore great hope for the inclusion of women's rights and recognition of the different lived realities for women across all spheres of their socio-economic and civil and political and cultural lives. Times ahead will now see that the complaint hearing mechanism for the Committee for Economic, Social and Cultural Rights has come into force and will start to hear and hopefully give comprehensive decisions regarding women's inequality and discriminatory practices against them, and continue to uphold the provisions of Article 26 to try and maintain the highest possible standard of human rights protection for women. The Human Rights Committee and the Committee for Economic, Social and Cultural Rights, which will soon start to give decisions based on cases that approach the committee, should now start to operate in cognizance with CEDAW and in cooperation with it, and there shouldn't be this marginalisation of women's rights to only fall under the CEDAW Treaty. Women's rights have been and must continue to be embedded within all human rights jurisdiction across the world. Recent evidence, for example the Melek case and recent general comments, demonstrates that this is a continuing trend, and a trend for the sake of women's rights we hope will all continue. This is the end of the module. Thank you.